Welcome to another Law Society of Yukon Continuing Development Professional Development course. Today, the Law Society of the Yukon Professional Development Committee is pleased to present Child Protection Law, featuring three wonderful speakers. First, we have Lauren Wildgoose. Lauren is a staff lawyer at the Yukon Legal Services Society, or Legal Aid. She's originally from Toronto and completed her law degree there in 2020. Was called to the Ontario Bar in 2021 and moved to the Lauren practiced primarily in child protection law, primarily served in First Nation governments in Northern Ontario before she moved to Yukon in 2022 to join Yukon Legal Services Society. Lauren now assists clients across the Yukon with family, criminal, child protection law matters. She also serves as jury counsel and White's child protection coach. Fidel Chambers is a member of the Champagne-Atiac First Nations. Have to remember it's nations, not nation. And he has an MBA in Aboriginal business and leadership from Simon Fraser University, and has dedicated a career to advancing the interests of Yukon First Nations. Shadell has worked in governance by working for and with various Yukon First Nations, including serving 8 years as an elected councillor. Shadell contributes to her community as a board member for many Yukon organizations. Shadell has served on boards including the Yukon First Nations Culture and Tourism Association, the Yukon Hospital Corporation Board of Trustees, and as an inaugural trustee of the newly formed Yukon First Nations School Board, which is a really wonderful innovation in Yukon. Shadell has also served as the executive director, has also been the executive director of the Council of Yukon First Nations, CYFN, for the last 8 years, and is the mother of term. Tammy, and you've got to correct me if I'm getting this wrong, Tammy, Shordnick?
Correct.
Practices Aboriginal law with Ratcliffe's LLP in Vancouver, BC. Tammy has a deep commitment to human rights throughout her legal career and is honored to advocate for and advise First Nations on Pacific claims, governance, Aboriginal rights, constitutional law, with an aim to facilitate reconciliation and assist First Nation communities in achieving and reaching the self-determination goal. Tammy has represented the Council of Yukon First Nations as interveners in numerous appeals before the Supreme Court of Canada and the Yukon Court of Appeal, including the Attorney General of Quebec, AL, and the Attorney General of Canada, AL, regarding the constitutionality of the federal act respecting First Nations, Inuit, Métis, children, youth, and families, SC 19, Chapter 24. Prior to joining Radcliffe, Tammy practiced at Bellin Law and McCarthy Tetro LLP in Vancouver and White & Case LLP in New York. She attended law school at the University of New York School of Law with a focus on International Human Rights Committee. International Human Rights. The CPD is been approved by the Law Society of BC for 2 hours. So I'll turn it over to Tammy, who's going to start us with an overview of some of the interesting things. And of course, as always, feel free to ask questions.
Thank you so much for that kind introduction. I'll just note quickly, I'm communicating with Shadell and she's just having trouble finding the link to join as a panelist, so she's working on it. So I am going to speak specifically about the reference decision on the federal act respecting First Nations, Inuit and Métis children, youth and families. This is known as Bill C-92. So this act was passed in 2019. Parliament enacted the act, and there's 3 really key elements to it. And the first is very unique for federal legislation or any legislation, frankly, and that is that Parliament affirmed the inherent right of self-government in Section 35 of the Constitution Act as including legislative authority in relation to Indigenous child and family services. So Parliament affirmed that Indigenous governing bodies have the inherent right of self-government with respect to making laws with respect to child and family services. So there was an affirmation within the act, and then there was also a statement in the act that made that affirmation binding on the Crown, which was also quite unique. The second aspect of the act was establishing national standards for the provision of child and family services to Indigenous children. That will not be my focus, and we'll sort of discuss why, but our intervention was not based on that. And my colleagues in the Yukon are much better placed to discuss those national standards in the context of the Yukon. And then the third aspect of the Act was it provided certain mechanisms to facilitate Indigenous governing bodies' exercise of that inherent right of self-government with respect to family and child services. So there were a few things it did. It provided that Indigenous laws respecting child and family services have the force of federal law and therefore have priority over any conflicting provincial law. That's the other thing. That this was one of the major issues that came up in the reference decision, and we'll discuss that a bit more. The Act also established what's called coordination agreements and funding arrangements. So essentially, an Indigenous governing body could give notice of their intent to draft legislation with respect to child and family services. They'd have to give that notice to the federal government and attempt to enter into a coordination agreement with the province. And after reasonable efforts, basically, if there was no way to make an agreement, if a year had passed, then the Act says that the Indigenous law had the force of federal law in any case. And then there were certain funding arrangements that could flow from these coordination agreements. So the government of Quebec referred the Act to the Quebec Court of Appeal, and they asked, it was a reference decision asking whether the Act was unconstitutional as beyond the legislative authority of the federal government, because child welfare matters are provincial jurisdiction. The Quebec Court of Appeal held that the Act was constitutional under the federal government's Section 9124 jurisdiction over Indians, and except for stated that the sections 21 and 22, which are those paramountcy and federal force of law provisions, basically the sections of the Act that said that the Indigenous laws had the force of federal law and therefore overruled conflicting provincial laws, the Quebec Court of Appeal said those were not constitutional. The Court of Appeal also held that all Indigenous peoples of Canada have a generic right of self-government to regulate child and family services, and that right is recognized and affirmed by Section 35. That was quite significant. This was the first time a court had recognized a generic right of self-government as opposed to a right held by a specific Indigenous community based on its specific practices and traditions. So this was a real expansion of Section 35 by the Court of Appeal. It did not stand, though, in the Supreme Court of Canada, unfortunately. So both the Attorney General of Quebec and the Attorney General of Canada appealed and cross-appealed the Court of Appeal's decision. The Attorney General of Quebec wanted the Supreme Court of Canada to say the entire Act was unconstitutional, and the Attorney General of Canada wanted to get those paramountcy and federal force of law provisions back in. So what was very interesting is in February of this year, the Supreme Court of Canada delivered a unanimous judgment in one voice, which is quite abnormal to have zero dissenting opinions, but speaks to the power of this decision. The Supreme Court held that the Act is constitutional in its entirety, and it was within Parliament's jurisdiction under subsection 9124 of the Constitution Act 1867, so that it related to Indians and lands related to Indians. My involvement with the case was I represented the Council of Yukon First Nations as an intervener. One question that sort of arose was Yukon First Nations have very powerful and broad self-government agreements, many of them do. And so where are we intervening, on what issues are we intervening? Because in many ways, this Act is not as applicable to self-governing Yukon First Nations. What we ultimately decided with CYFN is that we didn't want the Supreme Court of Canada to make a judgment that disregarded some of the important paramountcy provisions within those self-government agreements that do say that the First Nations laws are paramount to provincial laws and in some cases federal laws subject to negotiation. And we wanted to make sure that there wasn't some sort of collateral damage, if you will. And so, and obviously wanted to this was a great case for Indigenous rights and wanted to make sure it kept pushing forward in the right direction. But given that sort of specific interest and given the limited role of an intervener in the Supreme Court of Canada, we really focused our intervention on sort of two issues, and they're related. The first is a lot of the arguments from the Quebec Court of Appeal based on a lot of the arguments from the Quebec Attorney General based on the Court of Appeal's judgment was that Canada had created this new Section 35 right and that they were not permitted to do so. And the Court of Appeal did muddy that a bit. We argued that there was a Section 35 right to self-government with respect to child and family services, but that concurrently there was also a federal ability to legislate on that issue, that the two were not mutually exclusive. And so we argued the act was made pursuant to the federal government's power under Section 9124. And that didn't mean that there wasn't also a right to self-government, but they were affirming it, but that any of the paramountcy protections that were provided within the act were made on the basis of the federal government's 9124 power, and not on the basis of any Section 35 right. The court agreed ultimately. So as I mentioned, I'm going to focus sort of on that issue. I'll talk a little bit more generally about the case, but again, I'm going to leave out the discussion around national standards. But the Supreme Court of Canada did find the act in its entirety to be constitutional. So ultimately, the first major issue is this question of the affirmation of the right of self-government with respect to child and family services. The arguments from the Quebec Attorney General and others were that the federal government is announcing a Section 35 right. The Supreme Court of Canada knocked that down completely and said, no, the government is affirming, as the language of the act says, they are affirming their recognition of this inherent right of self-government, and it's in their ability to do so. It is a legislative tool. And what's really interesting is what it actually means. So from the court's perspective, the fact that the government both affirmed that there is this right of self-government, and that's in Section 8 and Section 18 of the Act, but then also explicitly bound the Crown with respect to that recognition in Section 7, the court said that basically has created a precedent where the federal government is now unable to go back and say there isn't a right of self-government with respect to child and family services. So it's bound itself to that position. And the court also said that not only can the government not deny the existence of this right going forward, but it also has to commit to taking a broad approach to interpretation of that right and to act diligently to implement that right. So this is a really interesting point. You don't really see affirmations like this very often. The Supreme Court of Canada sort of discussed why the federal government would have done this, and came to the conclusion that it was almost like a pedagogical exercise, that Parliament was using this act to communicate to courts, to society, to lawmakers, that the law must recognize the importance of Indigenous self-government with respect to child and family services. And the court said this is unusual, but it's an attempt to persuade other institutions to adopt the same position. And the court said that's completely valid for Parliament to do so, that the courts do not stand alone in sort of deciding these things or how things like this go. That is within Parliament's power. It's ultimately up to the courts to decide whether or not Section 35 does include a right to self-government with respect to child and family services, but that doesn't stop Parliament from saying that they believe it does, and they will act accordingly. So then the sort of next issue is in the reference decision was, does Section 35 include a right to self-government with respect to child and family services? The Quebec Court of Appeal said it did, a generic right. And again, this was quite groundbreaking. The Supreme Court of Canada declined to answer the question. The court said that question was not before it in the reference. The reference asked if the act was unconstitutional, didn't ask if there is or is not a Section 35 right, which is disappointing in many ways, because we would have liked them to sort of continue the Court of Appeal's decision on that front. But the court said it wasn't their role to make that decision when it wasn't before them, and that they could decide the question of constitutionality without touching on the content of Section 35. There were a lot of arguments around rewriting the test for Section 35, and this was finally the chance to do it. But the court said we have to leave this to another day. One thing that did come of the discussion, though, is in discussing how it did not need to decide if there was a Section 35 right, the Supreme Court of Canada did say that the fact that the federal government had affirmed the existence of this Section 35 right, and the fact that before doing so, the government had consulted with many Indigenous groups, had done lots of investigation and collaboration, would probably support a judicial interpretation of the scope of Section 35 to find that there is such a right. So, I mean, it's not binding, but it's something. So eventually, we assume that this question will end up before the courts, and this reference decision will obviously provide guidance. So the main issue, as I mentioned, that we intervened on behalf of CYFN was on this question of paramountcy of Indigenous laws over conflicting federal or territorial laws. And this was an issue. This was one of the sections that the Court of Appeal struck down as unconstitutional. Said it could not stand. The federal government could not state that an Indigenous law was superior to a provincial law in a conflict. The Supreme Court of Canada disagreed with the Court of Appeal and did find that federal legislation that's validly enacted under Section 9124, which it found this was, can give Indigenous laws the force of federal law and therefore paramountcy over conflicting provincial laws. And this doesn't preclude the fact that self-government rights of self-government on the exact same issue may concurrently exist. And so this was actually the argument we advanced on behalf of CYFN. So it was really exciting to us that they adopted it and agreed with it. The argument that we made was the federal government has done this before. This is not new. There's incorporation by reference of Indigenous laws as federal law in other instances, notably in the Indian Act, which is not an example we usually like to make. But in this case, it was interesting that the Indian Act at Section 88 provides that bylaws made by a band would have the force of federal law to the extent they conflict with the provincial law. And there are many, many, many cases discussing whether or not the ban law applies or the provincial law applies, and courts have accepted that the ban laws have the force of federal law. And this was never questioned. I couldn't find any case in which there was an argument that the federal government didn't have the authority in the Indian Act to incorporate by reference an Indigenous law as a federal law. So it provided at least this justification that this has been done before. And nobody has questioned the jurisdiction then, so why are we questioning it now when it comes to this issue of child and family services and self-government rights? So the court held that Section 21 of the Act incorporates by reference an Indigenous child welfare law made by an Indigenous governing body as a federal law. The court held that this anticipatory incorporation by reference was a completely valid tool for Parliament to use. The key here is the Indigenous law only has the power of federal law to the extent that it is enacted in accordance with the Act, with the federal Act. So again, going back to, there has to be that notice of intent to enact the laws, of that attempt to enter into a coordination agreement. It doesn't have to be finalized, but that these steps have to be taken. So as long as those steps were followed, the Act says the law has the power of federal law, and any conflicts with the provincial law, the Indigenous law overrules. One of the things that was interesting, I thought, during oral argument and throughout the discussions, was 2 days of hearings. I think there were 30-something interveners in this case. The court asked us, actually, about whether or not they could just delegate. Was this just a delegation of powers? Obviously, we didn't want that to happen. That would be very similar to the way that the Indian Act is framed. Basically, the question was, could they find that this was a delegation of power, and should they? And our response was, could they technically? Yes. Should they? Absolutely not. Thrilled to see that they did not go that route, for obvious reasons. So when it comes to Section 22, so Section 21 is this incorporation by reference saying the Indigenous law has the power of federal law. Section 22 is on the question of paramountcy, and that is just a federal law is paramount to a conflicting provincial law. And the court found that Section 22 of the Act restates the law on paramountcy and doesn't do anything new, which we had also argued is that it's just simply a restatement of the legal doctrine for clarity. And as the court said, it's ultimately up to a court to determine if there is actually a conflict between two laws. But if there were, because two laws could operate at the same time, if they can operate at the same time, if they're not truly in conflict, then a court will always prefer to have both operate. But to the extent that there is a conflict, the Indigenous child welfare law would overrule a conflicting provincial law. So that's sort of the summary of the reference decision. I'll just talk quickly about UNDRIP in the context of this decision, because the court did reference it a few times, and it was a large basis of oral argument for many of the interveners and parties. One of the things that the court did, which was very interesting with respect to UNDRIP, is the court sort of stated that UNDRIP has been implemented into Canada's positive law. Through the federal act. This is interesting because there was no real detailed explanation about that conclusion, but it basically was suggesting that UNDRIP was now implemented into Canadian law as if it were a federal statute, which is a development, because before the reference decision, it wasn't completely clear that UNDRIP was enforceable in Canada as if it were domestic law, as if it were a positive law. And there had been cases where UNDRIP was used as an interpretive tool, but wasn't given the full effect of a positive law. So this was a good development in that front. I'll just sort of close with, what does this mean for Yukon First Nations? Honestly, this is a very relevant piece of legislation for First Nations or for Indigenous groups across the country, less so for Yukon First Nations, because Yukon First Nations are already so far ahead of the game with respect to their self-government agreements. So many of the rights, powers, protections that are within this federal act already exist for Yukon First Nations in the context of self-government agreements. So, the fact that the court didn't erode any of those developments and rights and powers is great, but it ultimately means that the act is less practically powerful and useful a tool for self-governing Yukon First Nations. That said, it's still open. It's possible that there could be this idea of a hybrid situation in the Yukon where, this federal act can apply concurrently with Yukon legislation, Indigenous legislation on these issues. So there could be some sort of hybrid supplemental supports that are in there. There is the possible question of, the coordination agreements. Some First Nations might find it helpful to go through the federal act and then access the funding procedures and through the coordination agreements that need to be negotiated. There isn't a lot of sort of examples to go from. I think there are only 9 or so. I read a news article in BC recently where a First Nation had been trying to negotiate one for quite some time, I think months, a year, and the federal government had been stonewalling them. And then after the publication of the story, all of a sudden they had an agreement. So it seems like it's slow, but it's still open as another tool. But, as I mentioned, self-governing Yukon First Nations already have a massive amount of tools at their disposal because of the self-government agreements, which do have provisions for child and family welfare laws. There are already provisions around paramountcy. I won't speak too closely about that because my colleagues will touch on the Yukon experience. But yeah, that's sort of my overview of the reference decision.
Thank you so much, Tammy. Are there any specific questions for Tammy? Be quick. Maybe you give it a quick couple of seconds to see if there are any specifically for Tammy on the reference. But again, at any time you can Q&A or chat to get questions. I can ask them of the panelists, so we can, and we can have a cleanup at the end. Seeing none come up, I'll turn over to Lauren Wildgoose to give us to help us understand, to help us get a better understanding of the current situation in Yukon. You're here.
Hello, thank you, Bruce. My name is Lauren Wildgoose, and as Bruce said, I work with legal aid. I'm duty counsel here in Whitehorse. So that means that I represent pretty much exclusively parents who are going through court in child protection proceedings here. So that perspective means I'm going to bring things from the big picture and the lofty halls of the Supreme Court right down to the daily grind of the territorial court in child protection proceedings here in Whitehorse. And I'm going to talk about the amendments to the Child and Family Services Act here in the Yukon. Those amendments were made in 2022 after an extensive consultation process with stakeholders, including all the Yukon First Nations. The amendments are quite comprehensive, but rather than going through every single one, I'm going to highlight the ones that come up most frequently in my practice here. I think as another preface, I think it's important to recognize that court involvement in the family's life is not anywhere close to the beginning of a child protection process. So there's a lot of work that happens before I get involved, before other lawyers get involved, and the courts here that work is undoubtedly influenced by these amendments. So my comments are going to be fairly litigation focused rather than focused on prevention and the earlier protection stages, which I think the three of us probably share the opinion that is where we want our attention to be going. So as you'll hear and as you'll see from the preamble of the Act, the amendments here are largely made to bring our legislation into compliance with the federal act in terms of providing child and family services to Indigenous children and families, to set minimum standards for family and children services here in providing those services, and to implement the TRC calls to action with respect to those services. So I'll start with sections 2 and 3, which are the guiding principles and service delivery principles that guide family and children services here in providing services to all families. So Section 2 makes it mandatory that the Child and Family Services Act be interpreted and administered in accordance with a set of principles. One notable one here is that First Nation has to be involved in decision-making as early as practicable in decisions that are being made about a child who is involved in the system. So that means the First Nation, FCS doesn't just have to serve First Nation with the notice of application, which is also required, but they have to make all reasonable efforts to make a child's First Nation community part of the process of determining what case plan is in the best interest of the child. And that I would say is a recognition of the fact that First Nations have inherent jurisdiction over their children, as well as Section 12 of the Federal Act's requirement that child and family service providers give the Indigenous governing body advance notice of any significant measure taken with respect to the child, as long as it's in the best interests of the child to do so. These principles, the guiding principles, also recognize that preventative services need to be prioritized, and that's where we need to be putting our resources and attention rather than waiting until families are unhealthy and children are already at risk of harm. And the guiding principles also state explicitly that all reasonable efforts need to be made to reunify a child who is in out-of-home care with their family. So this principle kind of sets an explicit goal for the process, even where child protection services are provided in a way that's removed a child from their family. And I've seen this intention from kind of all parties, even once court is involved, and even where children are kind of in the last resort stage, being children in the continuing custody of family and children services. And that's been really encouraging. In terms of Section 3, the service delivery principles, again, there's an emphasis on involving the First Nation in the delivery of services for First Nations children, maintaining community connections, focusing on reunification with family, providing services in a way that's informed by holistic harm reduction and trauma responsive principles, in a way that's informed by an awareness of barriers to service created by systemic racism and biases, that considers the cultural, social, economic, and historical disadvantages that a child and their family may have. And in the case of Indigenous children, focus on achieving substantive equality with non-Indigenous children in respect to the outcome from the services provided. So the piece about substantive equality, I think is a good recognition of the Canadian Human Rights Tribunal decision, where First Nations children were found to be treated unequally as compared to non-First Nations children in the care of family and children services providers. Again, there's the focus on reunification, which is very encouraging, and harm reduction is kind of an interesting one. I think this is a challenging principle to uphold where children are involved. I think we as a society are just learning how to talk about harm reduction in general, and we're struggling a little bit as it applies to children and walking the line of protecting children, but also supporting parents who use substances with anything other than requirements of strict abstinence. So that's a challenging one, given that the vast majority of cases, certainly that I see in our court here, are child protection concerns relating to substance use and child protection grounds that stem from that substance abuse. So next up is the best interest factors. So these are the factors that a court has to take into account when making really any decision with respect to children in care. And these factors are substantially expanded in the new legislation to bring them into compliance with the Federal Act. And in particular, related to the importance of strengthening, not just preserving a child's connection to their identity, community, and family, because we collectively know that's crucial for the success of Indigenous children. So the new factors for considering the best interests of a child are the importance to the child of residing in their community and with their parents and any siblings or other extended family members, the importance to the child of being able to learn and practice the languages, cultures, practices, customs, traditions, and ceremonies of their family and community, and to access the knowledge held by their family and community. The child's sex, gender identity, gender expression, and sexual orientation. And if the child is an Indigenous child, the importance of strengthening their cultural identity and their connection to their community and traditional territory. So again, that's it's echoing the factors that are set out in the Federal Act, and changes the standard from preserving a child's cultural identity to strengthen it, and provides some more detailed guidance about what that actually looks like. So the examples of focusing on language, knowledge, and ceremonies that a child needs to remain connected to. I think it's worth mentioning as well the reference to a child's sex, gender identity, gender expression, and sexual orientation. This hasn't really been a factor in my practice so far, but it's I think important and encouraging given the ongoing attacks on trans children in the United States that's unfortunately now spreading to Canada. So this at least puts a bit of a floor in legislation here as well. Section 10 of the Act, the most relates to services and programs that are provided to children and families. And the most notable one here with respect to bringing our legislation into compliance with the federal act is the prioritization of prenatal care, which is in line with section 14 sub 2 of the federal act. And there's a bunch in between here, but I'm going to skip to section 45, which relates to case plans. So there's a section added here requiring that if a child is in the care or custody of the director, so Family and Children Services, the child's case plan must include a cultural plan, being a plan to maintain and support the child's connection to their language, culture, practices, customs, traditions, and ceremonies. And that case plan must be reviewed every 6 months. And then in making and reviewing that case plan, the Indigenous community the child belongs to, if any, has to be involved as well. So that provides having that specific guidance. Again, when I see it, it's usually in the context of an affidavit from a social worker presenting the plan from the child's care to a judge. But having the requirements for those specific details has been helpful, I think. And in terms of the people being invited to the meeting, I can't say for sure that this is the reason, but I've definitely had some very productive meetings with Family and Children Services, my clients and representatives from First Nations that aren't necessarily 6-month reviews, but I think our collective intent to involve all the important people at the table in case planning. Going to talk a little bit about party status and the right to make representations as it is set out in the new act. It's fairly consistent with the old legislation, and the requirements with respect to involving First Nations or an Indigenous governing body are not so strong, in my opinion. The federal act requires that an Indigenous governing body acting on behalf of the Indigenous group, community, or people that the child belongs to has the right to make representations, but it doesn't specify that they have party status in legal proceedings. And the Yukon legislation kind of says something similar, that the child's Yukon First Nation or Indigenous group, community, or people has a right to party status as long as an authorized representative attends the presentation hearing, having been served with all the relevant documents, which is the notice of application. So it goes a bit further than the federal act in terms of the First Nation or Indigenous groups' rights to participate. But I think it's a bit challenging, and what I've seen, the requirement that a representative of the First Nation or Indigenous community attend at the presentation hearing, which kind of functionally in hearing means the first appearance on the director's application. In those first appearances, they are, just by the nature of the beast, they're quite rushed. Often the parents haven't been served until quite maybe the day before for various reasons. And So I think the expectation in practice for a First Nation to send someone either by phone or if it's in Whitehorse, someone in person, is quite a barrier, especially as some of the capacity for First Nations to actually make someone available to respond so quickly to these processes is can be challenging. And I think Shadell might speak a little bit more to that, but that's what I've seen so far. However, regardless of that, they still, the First Nation or community group still has the right to make representations, which again is consistent with the federal act. So now I'll skip up to section 61 sub 4, which is the amendment to the act that comes up most frequently in my practice. And what that does is it changes the standard for a court to exceed the maximum timelines that a child can be in care. So it makes it easier to do that. Before, the maximum timelines that a child could be in care could only be exceeded if there were extraordinary circumstances. And now a court can make that order if it's in the best interest of the child to do so. And so just to give some context for the timelines, section 61 makes it so that a judge can't make an order to place a child in temporary custody, whether that's a temporary custody order, placing the child with someone in the care of the director, a supervision order, so placing the child in a person's care, even a family member temporarily, under the supervision of the director. Those orders can't exceed certain numbers of months, depending on the age of the child. So if a child is under 5 years old, then the amount of time in care can't be more than 12 months. If the child's between 5 and 12 years old, then it can't be more than 18 months. And if the child is over 12 years old, it can't exceed 2 years. So this section is a bit of a way of navigating the tension that comes up between wanting stability and permanence for children in care, maybe kind of hastening our way to a permanent order, versus giving parents or family members time to make enough progress on their healing journey for reunification to happen, because as the act says explicitly, that is the ultimate goal. And sometimes having kids in a kind of a temporary situation under a temporary order can be helpful if it's working toward the ultimate goal of going back with their parents. So in my view, that's an improvement, giving not only courts but family and children's services in exercising their discretion a little bit more flexibility in making kind of temporary baby steps, and giving a little bit more wiggle room before moving toward the last resort being a continuing custody order. And I think this is consistent with the federal act and the case law that we've seen dealing with it so far. There hasn't really been too much in the Yukon, but in BC, there have been some cases dealing with these principles. So that case law is kind of guiding courts away from looking at permanence in terms of staying with caregivers for a long time and prioritizing those attachments, and toward permanency in the sense of maintaining solid, stable connections to family, culture, identity, and community, particularly for Indigenous children. So one case that I think is helpful in kind of hammering that home is JW and BC Director of Child, Family, and Community Service. The citation is 2023 BCSC 512. And at paragraph 98, the court found that the federal act made mandates a broader analysis of attachment understood in the context of the need to protect and nourish Indigenous cultural connection. Attachment is not to be understood solely to caregivers, but rather to encompass a broader set of relationships with extended family, cultural community members, territory, and culture. The lesson from the Brown class action is that culturally alienating Indigenous children comes at tremendous cost to them over their lifetimes. The entire scheme for caring for Indigenous children set out in the Federal Act recognizes that caring for Indigenous children in a way that cuts off their cultural connections and values replacement familial connections, such as to a foster family, over their Indigenous cultural connections to extended family, territory, and community, is more likely to cause damage to Indigenous children than to protect them over their lifetime. So again, that 61 sub 4 gives us collectively a little bit more flexibility in working toward those goals. Next, I'll talk kind of on a similar note is the section 79 sub 2, which deals with adjournments of a protection hearing. So a protection hearing is the actual hearing of the director's application as opposed to the presentation hearing, which again in practice is usually a first appearance where an interim order is granted. So the protection hearing is the final one. And there are strict requirements. Protection hearing is supposed to be commenced within 45 days after the presentation hearing. In practice, that almost never happens. But so this section isn't kind of relied on in practice so much, but I think it's important that there are specific grounds for an adjournment or factors that a judge has to consider in making an adjournment decision that specifically contemplate pathways to reunification. So again, seems to me like an acknowledgement that keeping a child in care for a bit longer, if the goal is to make reunification more likely, is quite possibly worth it. So section 79 sub 2 states that a judge, when making a decision to grant an adjournment, has to consider these factors, and they're whether an adjournment would promote family reunification by providing parents with the time to access treatment, secure housing, or otherwise take action that would allow the child to return to them, the effect an adjournment would have on the child returning to their parents in a timely fashion, and the effect an adjournment would have on the ability of a child to access their culture and their community. And I think the reference to giving parents time to access treatment or secure housing, those are really kind of Yukon specific examples. Those are the two biggest barriers to reunification that I have seen in terms of parents needing to get to treatment for substance abuse and not having secure housing. And finally, section 89.01 gives a bit more guidance and detail in terms of priority of placement, prioritizing where a child who is in care has to be in accordance with the Federal Act. So those provisions are essentially echoing the priority of placement provisions in the Federal Act and bring them home in the Yukon legislation. So that's about it from me. I can turn it over to Shadell now.
Thank you, Lauren. Are there any questions for Lauren quickly? Doesn't appear to be. Well, I hope we'll get some questions, because those are always one of the ways I find is really useful to learn in these situations, is to have the great mind of question lawyers cross-examine our panelists. So next up we have Shadell to kind of go over the last couple of things in the last few kind of combine the variety of things we have been learning. Shadell, go ahead.
Thank you, Bruce, and thanks everyone before me. As I want to be clear that I'm not a lawyer, so I will try to provide some reflection on what these two pieces of legislation mean to our community and on the ground level. And so maybe just back to Tammy's piece around C92. She spoke mostly on in her inherent jurisdiction in the reference case decision. But I think it's really important to highlight C92 has two main streams. One is the inherent jurisdiction component, but the other piece is national standards. And I think it was really important and insightful to have national standards in regards to child welfare, because we know how harmful the system has been historically and continues to be. So the three main points that I wanted to just quickly highlight on C92 in regards to the national standards was that the legislation includes the three components that speak to the best interest of an Indigenous child. So it's noted that most legislation says best interest of the child, but the C92 legislation specifies and defines best interest of the Indigenous child. The second component is the importance of cultural continuity. And as a national standard, ensuring children are connected not only to their family, but also to their community and culture and language. And then the third piece really being around substantive equality, which recognizes that Indigenous or Yukon First Nations, Indigenous First Nations people are not starting off at the same level due to historical disadvantages, colonialism, residential school, racism, discrimination. So on those three pieces of the national standards under C92, I think there's still a lot of work to be done there. And I'm not actually sure if any, I don't know if it's the right language, but, test cases went before the Yukon courts in regards to, maybe even what the best interest of an Indigenous child or a Yukon First Nation child. I think there's space and area around that. So what I tend to see in our practice and our work with families is that Yukon government is supposed to be in compliance, and we did a lot of work to try to get to compliance in the review of the Yukon legislation. I actually co-chaired that 18-month working group with the Director of Family and Children's Services. There was a lot to learn there, and we tried our best to make it in compliance, but I think there's still a lot of room for work and interpretation. Unfortunately, as we know, most families are living in poverty and don't have access to justice. Lauren does a lot of great work at Legal Aid, but I think that there is a lot of space and room to continue to push Yukon government to be in compliance. A couple of pieces that I did want to state just to set the context here, and I want to just look and ensure I have the right data. The latest data we received on a quarterly basis from Family and Children's Services is that there are 92 children in the director's care here in the Yukon. 66% of those are Yukon First Nations, but when we add other Indigenous, including Inuit, Métis, and other out of territory Indigenous children, that total goes up to 96%. So that is quite a significant overrepresentation, and that's unfortunately the historical reality. And so one of the intentions of C92 was really to help address that overrepresentation. However, if we don't have the capacity and the money to go to court to push some of these pieces, I think there's a lot of space there. I won't speak much more on C92. There's a couple other important things that it mentions: notification to families in regards to changes in significant measures. And I think we have a lot of work there to define what significant measures is that when a child has a significant mental health issue, a medical issue? Is that when family or children are transferred between group homes or foster parents? So I think there's still a lot of work to be done there. Of those 92 children in care, the majority of them are in foster care with non-Indigenous care providers. So that still remains a huge gap. And how do we expect non-Indigenous caregivers to support cultural continuity? There's a lot of work to build caregivers' capacity and understanding. We've often looked and worked with Yukon government to change the foster parent agreement to make cultural continuity a part of the contract. And I think that recently just changed, but that has been a 3 or 4 year hard push to get that included. And of the number of foster parent homes in the Yukon, 43 foster homes, and only 12 of those are Yukon First Nations, which only represents 28% of foster homes are Indigenous. So you can see there's quite a large gap there. The other important piece of data is, yes, there's 92 children in the director's care, which means they are, not living in their home community with their family. And all group homes are located in Whitehorse, so there's a big disconnection there. There's also a pretty progressive agreement and ability under the Yukon legislation to have an extended family care agreement. That means the parents' legal rights are not extinguished and they can be placed with family. So there are currently 96 children living in extended family care agreements. So I always add the 96, approximately 100, and another 100 or 92 in group in the director's care. We all have over 200 Yukon First Nations children being raised by their parents and disconnected from their communities. So I think that's important context in this conversation. I didn't know Darren Lease was going to be online, so I'm stealing a couple of his slides, but there are many tools in the legal landscape of child welfare for Yukon First Nations to use to help address some of that overrepresentation and ensure children are connected to their community. So we have the Yukon Child and Family Service Act, we have Bill C-92, the federal act, and then through the self-governing agreements, we have the ability to enact our own laws related to child welfare. We have opportunities through negotiations of programs, service transfer agreements, and then there is also the division and sharing of child welfare powers. And then through the self-government agreement, Section 13, administration of justice, we can also have the abilities to First Nations court. So I'm not a lawyer, I don't want to get into that, but Yukon First Nations have a lot of tools in regards to that. In regards to the Yukon legislation, Lauren went through it pretty well, but I will just say a major component of the review and the revisions was to really focus away from, it's a fine balance between permanency and reunification. And so we ensured that a reunification was included in the principle, guiding principles. What we often found was a child came into care and they remained in care. There was not a lot of effort on behalf of Family and Children's Services to always continue to push for reunification and help support those pieces. So that's now a part of the legislation. And then Lauren also mentioned the cultural plans. Cultural plans are now legally legislated, but I will say out of those 92 children in care, there's probably less than 7 cultural plans currently developed here in the Yukon. So still a lot of gaps in regards to addressing some of these pieces. Back to the Yukon legislation, Section 21 talks about when protection intervention is needed. Terminology changed through the last legislation. It went from neglect to emotional harm. I think neglect can mean different things to different people, especially when we're talking about cultural differences in the way that First Nations have child rendering beliefs and values. And so this legislation speaks to emotional harm, and we still have different interpretations of that. We often see maybe a non-Indigenous social worker believes there's emotional harm because of some of their biases, some of their values around parenting, and then what Indigenous and Yukon First Nations families have as traditional practices. Emotional harm is the most used intervention under the legislation. We rarely see physical harm and sexual abuse, although it does happen, but well over 50%, probably closer to 75% of the cases for intervention are through emotional harm, and that's mostly due to the harm that children are experiencing because of their parents' addictions. And so again, just being mindful of those historical intergenerational traumas. What this morning and yesterday, Yukon government's frontline child protection social workers are all doing core training this week, and we co-developed that with Yukon government. And so we went to speak a number of times, and we'll continue to do that, about the harm that the current child welfare system legislation and system that it's built upon really is really protection intervention focused, and it's not so much on the prevention, supporting families way ahead of the crisis scenarios. As Lauren mentioned, access to treatment is a huge gap. There is not a Yukon First Nations led treatment center here in the Yukon, and access to housing. So affordability is basically unattainable in rental form for our families, because one of the structural root causes for family involvement in the child welfare system is poverty. And so the Council of Yukon First Nations over the last number of years, about the last 5.5 years, has developed a new frontline service called Family Preservation Services. We now have over 42 staff in this department that help support families navigating the child welfare system, but also a lot of prevention-based services. So how are we supporting families? And being able to access Jordan's principle and really helping support families get the supports they need. We just got data for the end of October, and our stats show that we are supporting 411 Yukon First Nations and Indigenous families in one way or another through our family preservation supports and services. And so that's really frontline working with the communities. We are housing 25 families currently each month and supporting an additional 45 families with rent top up, because housing is such a huge cost right now, and the cost of living. And so we want to maintain families at least have housing and help address some of the other root causes, such as intergenerational trauma and the symptoms of addictions and violence that come along with that. I want to allow time for questions, so I'll finish there and look forward to hearing some questions.
Thank you, Shadell. I think it's just getting a little moment to get the camera back on here. So yeah, like Shadell said, we've got lots of time, close to an hour for questions. So I'm really eager to hear from everyone what they think of the questions. But I think while we wait for others to get involved in questions, I really do encourage you. One question that really does come to my mind, and I know it's just having talked to Lauren and other institutions, is something that she's mentioned to me. It is without that broad systemic change, that's just systemic change through PSDAs, indigenous governance agreements, PSDAs. There's a million, and I know Darren could probably pop into the chat and talk on about a dozen other things I'm missing, and will probably explode my phone with all the things I should have touched on there. But what in the current section, should all to you, if you want to touch on that, what more should or can Yukon First Nations be doing to support children in care? And the one category that I think was interesting with Shadell about children not being raised by the family members is I know that there are a lot of children that they get into foster care, and as it gets to be almost their family, it ends up turning into more of an adoption situation as well. Anyways, so that kind of question about what more can, should, and would First Nations kind of be able to, should do, absent those broad systemic interventions.
Yeah, thanks, Bruce. I think, your comments, and historically, child welfare system has been the pipeline to adoptions. And that's why we hear of things like the 60 scoop, the millennial scoop. And so here in the Yukon, that is no longer a practice. And I believe Yukon First Nations may have a veto in terms of adoption. So that is a good point. And I think, when we look at those systemic issues, we have to address them. From my point of view, I think, as I mentioned, there's lots of tools for Yukon First Nations, both self-governing and non-self-governing, to now use to take back their inherent rights in regards to their families and children. What I see is the issue is no longer money as well. So the Canadian Human Rights Tribunal has issued numerous decisions, and there has been tons and millions and almost billions of dollars being rolled out for child welfare reform. And here in the Yukon, we have a trilateral table, both the federal government, Yukon First Nations, and territorial government. Over $150 million has come to Yukon First Nations directly in terms of prevention and supports for child welfare reform. The biggest gap we continue to see is the capacity to occupy that space. So, everything from frontline social workers to just the capacity and infrastructure in communities to do this. Do we have group homes in communities? Do we have people identified to create safe spaces for families? Many of us in smaller communities are well aware of the families that are struggling. You see it every day. You see it within the communities. We know families are struggling with addictions and housing and all those pieces. And so how do we take back those traditional roles of helping create safety for our communities and addressing some of those root causes and structures of why people and families get involved with child welfare? And then when and if they do, how are we working to reform practice? Working closely with the legal system. As I mentioned, access to justice is a big gap, but it took us almost 2 years for CYFN to get the child protection court docket. So every Thursday morning we're there now, and we're doing lots of work with Lauren and her team and coming up with case plans and helping support those families get to court. So my biggest piece is Yukon First Nations really need to, they have the legal framework, they have the money, and now we need to really build our capacity. Finish, Chish.
I can jump in briefly. Not that this is my area, but just something I'll, I guess, mention some really positive supports and contributions that I've seen working with First Nation representatives. One big one has been giving support to the parent and kind of by extension FCS in terms of specific guidance in cultural planning for making a case plan. Because sometimes FCS will express an intention in a case plan or in the terms of a court order to recognize a child's identity as an Indigenous child and do cultural programming, facilitate cultural programming in general, but not specifically, they might not have that knowledge about what that looks like in recognizing a child specifically as a Trandakwachen citizen or a Vantakwachen citizen. And that's from what I've seen has been really important to parents and children in making that connection, really preserved, strengthened, and maintained during their time in care. And another kind of ongoing challenge, and it's maybe a bit of a division of labor piece, we're still kind of figuring this out, I think, is the frontline kind of connection, referrals, connection to services like treatment. CYFN's Family Preservation Unit, like Chantal mentioned, does great work in that respect. Sometimes it can be for First Nations who aren't in families who are in Whitehorse, it's a question of, does CYFN support with that? Would it make more sense for the First Nation to do that? And in certain cases, a representative from a First Nation has been offered really great support in that sense, and where that hasn't been possible, then CYFN has provided that support. So that's another area that I think we're kind of collectively working through as to who provides what kind of support in that area.
Thank you. I don't see any more questions, but one thing I would kind of like to throw out, and I think this can link into the federal stuff as well, and really into human rights, which I know is Tammy's passion. So hopefully she can kick in. But the one thing that one of my passions is disability advocacy. I mean, I'm one of those people that people say there's something up with him within minutes of meeting me. But in terms of I think support for disabled individuals, both parents and children, because there's enhanced difficulty if there's a disability, if there's significant disability, or autism, or others where there might not be the resources in the community, and in small communities. I mean, Jordan's principal's obviously done a lot of really awesome work for First Nation communities, but I don't know if we're there yet, or just the school's not getting certain students in the past, in the past and now. And I just think, both on the education piece and on the disability piece, how that links back to a lot of the challenges we're facing. I mean, my experience working in criminal law it's a very small when you look at the what I say is right is the repeats people who are, I think the technical term is prolific offenders. We might call, criminal lawyers might say repeat customers, frequent flyers, whatever. If you look at them, there's a pattern of, one is child welfare, and also with them, a lot of mental disabilities that may not have had the proper resources and stuff to need. And so I just kind of want to link some of that into some of this discussion we've had on child welfare, and anyone who wants to jump in can.
I don't mind to maybe jump in and then Tammy, but I do think, a lot of this reform is stemming from a Canadian human rights decision, obviously, and there continues to be, I think they're at 43 non-compliance orders, and there was just one issued next week. And so I just want to, say that we're seeing a transformation. We're in the middle of it. There's a journey. As you mentioned, Bruce, there's lots of supports for children through Jordan's principle and those sorts of pieces. How do we support adults with disability, parents with disability to, stay connected to their family and community? And so I just wanted to kind of mention that. And it will be interesting to see, because of the final settlement agreement coming through the AFN and the Caring Society was rejected. And people want to see the Canadian human rights still occupy that space, or whatever the right terminology is, but their jurisdiction will be ending soon. And will we continue to see cases brought that way to get the reforms that we need to see? Tammy?
Yeah, Bruce, yeah, thank you for that comment. I think it sort of raised for me this concept of, there's a lot of moving parts that are impacted. And I think particularly in the context of the reference decision, it's phenomenal to say that Indigenous governing bodies have the ability to create these own laws, and that those laws take precedent over any conflicting laws. But then the question becomes, and this sort of speaks to Chadelle's points a bit more, and Lauren's, that well, then what now? And who's making sure that all of these interconnecting issues, disability, children, family, criminal, that those are being addressed adequately, because it's what we don't want to see is an offloading of responsibility to just say, okay, well, you've made the laws, now it's, here's some money and it's in your territory, and where's the capacity building, and this more holistic approach. I don't think that we know how that will work, and that's certainly a concern, of how will these things actually play out in reality and on the ground.
I also think the offloading comment is a really important comment. As I mentioned, Yukon First Nations have received over $150 million in prevention-based services, but what does that mean? What's the liability associated with prevention-based services, working, with high needs families and all those supports and liability that comes and risks that come with it, right? We hear many systems, whether it's child advocates or youth representatives, where children are dying in care all the time, and being lost within the system and being harmed. So I think there's important conversations that need to look at, as you mentioned, Tammy, through a holistic lens, understand the cultural, community-based pieces, the capacity pieces, but also understanding the risk and liability coming along with that. And then just like economies and scale here in the Yukon, can we have 15 different child welfare systems? I think another tool in the legislative framework is there are delegated authorities through the Yukon legislation that can, we see south of 60 all the time, and that can be a phased approach where people build their capacity. You don't take on child protection on day one. Maybe the first couple of years is prevention-based services and supports to caregivers or something. And so really looking at a phased approach while building our capacity.
So I'm not sure if you can see it, but there is a question in the Q&A tab at the bottom. Are you able to see that?
Yeah, I'm going to read that now. I was just making sure anyone who had a chance to answer the other one had. So this question is from an anonymous attendee. As a former foster parent, I have seen Family and Children's Services make arbitrary determinations for children and stick them in group homes. For example, instead of a family, so that'd be group homes over a foster family. Do you see the possibility for advocacy for foster parents who can work with a children's lawyer, or maybe more precisely, how can they work with a lawyer? How can they be involved in that? I think we've all seen some times where there's very positive relationships with foster families, and I think personally to one of the really tragic criminal law cases where one of the big things was in that case, I forget which one of it. I think it was MD. A big thing in that was basically that child. This is years ago, so a very different system. But that individual was denied basically the chance to be in a loving, positive foster home, and so dragged from group home. So I think this is a very important question to answer, even though I think we all do recognize that foster homes might not be the ideal solution that we all want.
Yeah, they're a very much needed resource within the continuum of child welfare. I will say there is not a foster parent association in the Yukon, which is a bit of a gap. Other jurisdictions do have those. And we are actually seeing a trend nationally, but also here in the Yukon, with the decline of people wanting to be foster parents. It's very hard and challenging right now to recruit foster parents, not even to recruit Indigenous foster parents. Hence why we are seeing such a drastic increase in the number of children going to group homes. Currently in the Yukon, there are probably 10 children under the age of 3 in group homes. We can actually have 2 dedicated nurseries to babies in group care. So it's really unfortunate. And we know the outcomes for children who are raised in group care are unfortunately worse than any other component and resource under the child welfare system. And so, I think there's lots of work to be done on the prevention-based side, but also work to be done in terms of the current system and how we're reforming that. Foster parents aren't happy, as you mentioned in the question, arbitrary decisions made by FCS. Now there's additional components on them to support cultural continuity. And as we mentioned, a number of them aren't Yukon First Nations. And so the requirements and expectation of foster parents are drastically increasing. And I will say, if your child does not have high needs, you're receiving $1,200 a month to support a child, which isn't always adequate either. So there's many different factors and variables that make it very complicated.
I don't have a ton to say on this one, but in the federal act, the Yukon legislation doesn't really deal, or the amendments don't deal with this issue so much. But in the federal act, the Family and Children's Service provider does have to give notice to the care provider as well as the parent and the First Nation of significant measures taken with respect to the child. As Shadal said, there's a bit of ambiguity as to what that is. I would definitely interpret that as a change in placement. The care provider or the foster parent would need to get notice. But there is certainly not a lot of attention to that in the amendments to the Yukon Act. I think because the kind of general emphasis is shifting away from attention to contracted care providers and toward family and reunification.
Yeah, and maybe just one last further point there is we also have big challenges in terms of being able to work directly with foster parents. So one, Family and Children's Services will not give us a list of names to help support, family foster parents. They sometimes need their own advocacy through those pieces. And so again, there's been no testing of those significant measures in the Yukon, right, Lauren, that you're aware of? And so I can say, like, for sure, YG or Family and Children's Services is not in compliance, and I can name 10 cases right now. But until First Nations have the access to justice and the resources to fight the fight, YG can kind of basically do what they've been doing and not really being held accountable. And then, so there's I mentioned to everyone, like, anybody got a pro bono lawyer, let's try to do some of this, because there's lots of work that needs to happen here in the Yukon.
Thank you. I know the other thing that's kind of linked to this, it has been talked about for years, and often particularly with higher needs individuals and the higher needs children in the foster care system is really also supports kind of I don't know if it's changed, but I know a few years ago the big conversation was basically it's 18 it's a switch at 18. At 18, it's kind of out. So I mean, I think that's obviously a challenge, particularly can be for some children who may have been in a single foster care placement for a long time, and particularly and then there's no supports to carry them on. They have to get into adult things. You can't get that if they're living with the foster family. So it seems that seems something that really kind of troubled me in the back of my mind as I was hearing about how do we support family is supporting that real just transition to adulthood, including involvement with the foster families if they're willing. If that's something they remain keen on. And again, always encouraging anyone who has questions to answer. I think that anyways, just wanted to see if anyone had any.
Bruce, just maybe on your point there, and I don't think Lauren or I highlighted, the Yukon legislation actually changed to provide post-majority supports up to the age of 26. So that also came from the Canadian Human Rights Decision and the reforms happening through the federal program. So I just want to highlight it. And yeah, it previously had been a gap for generations. However, we're seeing not a lot of youth take those advantages of those and have their own involvement with family and children's services. Unfortunately, we're seeing generational involvement now.
So I know we're booked until 2, but it doesn't appear to be any questions, and I don't feel very good just keeping asking a bunch of questions here. Although, I as people know about me, I could probably figure out questions and for another half hour. But I think it's just really thanking the panelists for the good work they're doing. It's very important that we keep building on these strong foundations and incorporating them and building them into that into those governance models. I'm certainly some of the work I'm starting to get, I'm very honored to start to get involved in, very very excited to be involved in with a lot of the groundwork Tammy's lead at the Supreme Court of Canada, with that amazing intervention that I was so excited I got to be on a few, was like so excited I got to be on a few of the early calls for that, which was really something that was cool. And then, I think it was really some of the really groundbreaking stuff that was laid for the court. So thank you a lot for that, Tammy. So, hearing a lot about the really wonderful day work from Lauren, in the trenches, trying to making changes, making positive impacts on a day-to-day basis. In the grind of the territorial court, I always think of some of those cartoons that you have of the territorial court where it's fist fights at the provincial court and then erudite things at the superior court. So, thanks for being in the trenches and kind of that baller for the children there, Lauren. And Chanel, again, thank you a lot for the really wonderful work that CYFN and the leadership in the leadership that CYFN takes in these things. It's important. I think as we go forward, we're obviously going to have a lot of those big conversations with Yukon First Nations over what kind of model actually does make sense for Yukon indigenous groups. Doesn't make sense. Does it ultimately make sense for us to have 15, 16, 17, thinking with transboundaries, interjurisdictional agreements and all that, child welfare systems, for 40,000 person population base. So, probably at the end of the day, it doesn't. Probably there's going to have to be some level of collaboration, but there's also has to be some fundamental things that recognize cultural connection. Connection cannot be an ambiguous connection to indigenous people. It has to be cultural connection to a specific community, to specific clan relationships. Again, more so than Yukon with Tlingit, which I know I'm not too, but broadly familiar with some of the special clan relationships within their cultural connection, families in the north or in a specific community. So I think this is all good work and something that's going to be continuing, and obviously something that we have to work with partner governments, and something I really hope our Yukon government partners have listened. So we thank the panelists. There are some small, we do have some small gifts for them. Tammy, I believe yours will be mailed to you. So thank you very much for your time, and thank you all for attending, and thank you very much for the questions. as a reminder, this has been a CPD presented by the Yukon Continuing Professional Development Committee of the Law Society of Yukon. Thank you so much. Thank you so much, and we will talk to you. Thank you. Have a nice day.
Thank you, Bruce.